Hello everybody, very warm welcome to this first regulatory and compliance update of 2026. We are only a week in to the new year, but all sorts of different things have come onto the agenda which I'll be covering, which will obviously mean that you will need to put your focus on those particular issues. But let's move on just to, for those who haven't been with us before, onto administration. If you have any questions, if you put those on the system, and I'll pick those up at the very end. If you're a solicitor, it's A2 for competency purposes. We are recording the session, so if you want to pick it up later and use it for internal training purposes, then please do. The slides, I loaded those onto the system earlier this morning, so if you would like to pick those up, then you can. In terms of LinkedIn, I've been very, very busy on LinkedIn, as you'll see in a moment. But if you want to follow me, then please do so. In terms of links, we've got those at the bottom of the different slides. So if there's any further details that I think you need to have access to, you can click on the links there. And of course, we've got other webinars coming up, which I'll talk about in a moment. And so if you want to save a seat for those, then please do register for those. So I just spoke a moment ago about what I've been doing on LinkedIn, and here are the most recent things I've done. Again, I'll be covering them in a little bit more detail as we go through, but if you want to pick up a lot more of my thoughts and things like that around these different issues, then please do go to LinkedIn and you'll see what I'm thinking around those. Had a lot of good interaction with people on LinkedIn about them, so you might want to have a look at what I'm saying, but also about what other people are saying as well. In terms of webinars, we've got a number this month. Obviously, we're here today, but we're doing a horizon scanning webinar next week where we're going to be looking at things that are sort of coming in 2026 and things that are potentially likely to land in 2026 as well. So if you want to come along and have a look at what potentially is going to be happening, then you're very much welcome. And we've got our AML quarterly update as well on the 22nd of January. So if you want to see what's going on around the AML piece, then please do come and join us. And there is a lot going on around that piece at the moment. Just to let you know, if you are a CQS firm, that we are currently working with CQS in relation to the new training courses, and subject to the Law Society and what it's doing sort of internally, we are looking to launch on the 19th of February. So we've got updated syllabi for the conveyancing practice and risk and compliance and client care courses. And we've obviously got supporting webinars and policies included in subscriptions that we have. So if that applies to you, then just keep an eye on that one and we'll let you have further details in due course. So on to the main event, something which just follows on from the last webinar that we did in December. I was hopefully assisted by somebody on the call to just remind me of the extension notice that had been put out by the Legal Services Board. This is in relation to the changes to the first tier complaints arrangements. So we're just waiting now for the decision from the Legal Services Board in terms of what the SRA is proposing around these first tier complaints rules. And we're hoping for a decision on the 11th of January. So again, only a couple of days. So just keep an eye on that one. Again, once I know the detail, I'll be putting that out on LinkedIn, but I'll also be putting that out on the webinar next month. So one to watch. When regulators become defendants, so this is one of the LinkedIn stories that I've been working on. The SRA is being sued, believe it or not, and it is going to be a real case to watch, this one. This is the insurers around Axiom Ints. Many of you will know what happened there. £64 million has disappeared, and the profession at the moment is having to pick up the pieces through the compensation fund and other ways. But basically what's happened is the insurers have picked up on this and they are suing the SRA to say, well, had you done your job properly, we wouldn't be picking up the pieces of the scandal. So it's going to be really interesting to see what happens here, because of course, if the SRA loses this case, then I use the phrase on LinkedIn, basically it's going to clip their wings. How far it clips their wings is another matter. Obviously, if they win, then we know where we are. We're basically going to be staying where we are. But I think it's a real case to watch, this one, and it could have real ramifications if the SRA can't enforce in the way that it has done in the past. It then has to change the way that it is doing things to make sure that insurers can't then go for it because it was asleep at the wheel, as some people have said. So watch that one. And again, I'll be doing lots of stuff on LinkedIn as I sort of get to know about it. Compliance officers. I have to say, over many years since this came in, what was it, 2013, January 2013, I've been calling for the SRA to do a review of the COLP regime because of all the issues that I've been seeing through the SRA enforcement, the SDT cases, and other things that I've seen when I've gone into firms. There are a lot of people who I don't think are appropriate for the roles. They've admitted it themselves. And the report that you can see here, I mean, you can go into the link at the bottom there and you can have a good read of all of it. But certainly a lot of the compliance officers that they interviewed were basically saying, we're not appropriate for the roles. So it's an interesting one, this. So just looking at the data here, 54% of officers don't feel valued or didn't feel valued. Well, that's understandable. A lot of people will see compliance as being a barrier to business and things like that. It depends how you sell it to your colleagues and things like that. But the fact that people are feeling undervalued isn't a good sign. Out of all the people that they interviewed, and I have to say I was very curious about the numbers on this because they only interviewed, I think it was just short of around 30 people. Well, bearing in mind that there's around 9,000 law firms, so there's got to be about 9,000 COLPs, and they only interviewed about 30. Whether you can take all this data on, and sort of use it scientifically, I'm not quite sure. But anyway, only one officer could describe the material requirements of their role. Well, that is really concerning if you were to then extrapolate that across the whole profession. I don't think that would be the case, but you can see where I'm coming from on that. 20% of officers couldn't explain their record-keeping obligations, and that's really important because, of course, you've got to keep an audit trail for the SRA, and particularly around AML. And I've noticed, again, they're sort of on the trawl for firms to provide data and things like this within, I think it's 10 days. So, they're doing the AML reviews again. So that's something to watch out for. And I have been made aware of firms that have received the letters, emails to say provide the data. 50% of officers had read the SRA's reporting and notification guidance. Again, this is something that the SRA has picked up previously, where people are not reading warning notices and things like that. Well, a lot of, and again, you can read this in the report, but a lot of people were basically saying they just don't have the time to be reading everything. I did a page count some months ago around AML, and I think I counted about 1,600 pages of relevant legislation and LSAG and all the other bits and pieces that go with it. Well, if you're a busy fee earner, where do you get the time to read all this stuff? And then if you've got all this additional stuff coming out from the SRA and the Law Society and everyone else, where do you get the time? Well, of course, it's my day job to be reading all this stuff. But people who are busy fee earners and looking after their clients, where do they find the time? Well, unfortunately, they have to find the time. Otherwise, they do risk, obviously, being at the wrong end of the SRA. So I think it is very much worth reading this, whether you are a COLP or not. I think it gives you an insight into where things are with the COLP regime. I don't think it works personally. I have made representations to the Justice Committee and the Regulatory Committee in the Lords on this. I think there needs to be a complete review of the regulatory regime within the legal sector at the moment, particularly around the SRA, the Bar Standards Board, who have obviously been heavily sanctioned. But when we've got compliance officers who are responsible for, in effect, reporting misconduct and all that sort of thing, a lot of COLPs will be employees. Are they going to want to upset their sort of paymasters? You've got perhaps junior equity partners who don't want to sort of get on the wrong side of senior equity partners and all those sorts of things. So really, does the COLP regime work? And I'm really not sure based on this report. And as I say, it's not scientific based on 30 people out of 9,000. But I still think, looking at everything from where I am and what I see, it's definitely not something that works. Now, whether we go back to something like the Practice Standards Unit, where firms have visits every 3 to 5 years, and I know when I was in practice, I was involved in some of those. It keeps you on your toes. It makes sure that you're doing the right thing. So whether that works or not, I don't know, but it will be interesting to see where this one goes. AML Supervision Transfer, if you haven't heard about this one yet, well, we're going to be moving, or potentially, I say potentially moving because it's all under consideration at the moment, but the government has said it wants the supervision of AML in the legal sector to move from current legal regulators over to the Financial Conduct Authority. Excuse me. So we need to be sort of preparing for this one. I was talking to a colleague earlier on, and we've sort of got it on our 1 to 6 month watch list. Well, you can see there in the purple box, timeline is a number of years. Well, that's what we've sort of seen coming out from government and regulators and things like this. But I think because of how this could impact on firms, that's the reason why we put it in the sort of the 1 to 6 months, because it's something people need to watch out for on an ongoing basis until it happens, or we get a decision to say it isn't going to happen. I've already put in my thoughts to the government in terms of whether I think it's going to work or not. I think there are some real concerns. And again, I think I put those on LinkedIn. But one of the concerns that I've really got is in terms of the disjointed regulation regime that's going to be operating here. So, are we going to find that if it goes to the FCA, that a firm is then picked up for breaches of the money laundering regulations, and then it's passed back to the SRA for professional conduct issues to be addressed, which means we've then got a sort of a double whammy. So I think there's all sorts of issues here, and others have picked up on it as well. So watch out for that one. We've had a lot of the main law societies. So the bigger law society, I think they call themselves the Big Six or something like that, both in Scotland and England and Wales, basically going against the recommendations or the proposals that have been made. So whether it happens or not, I'm not quite sure, but we'll see. SRA prosecution ruled fatally flawed. So the SRA, you are going to have to pick up the tab because they've been ordered to pay £160,000 in costs for a fatally flawed prosecution. And I think it is worth having a look at the link at the bottom there. So the case was basically dismissed. I don't think they even got to sort of hearing evidence after the SRA because basically it didn't have any, or what they had just wasn't worth looking at. And so on a very, very rare basis, the SDT ordered costs at the SRA. A lot of firms, a lot of individuals and firms haven't had that luxury, even though they've been found not guilty. So we've seen a couple of cases recently where there's been hundreds of thousands of pounds of costs. And even though they were found innocent, they had to pay all of those with their businesses being ruined, mental health issues and all those sorts of things. So again, it'll be interesting to see where this one goes. I think I put it on the Law Society Gazette website or article or LinkedIn again, basically saying, well, maybe the new CEO of the SRA should be coming out now and saying, well, what's going to happen with the staff that brought this particular case? Are they the right people to be in the SRA looking at this type of thing? So we'll see again what actually happens. But unfortunately, as I said right at the very beginning, it might look as if this is the SRA paying, but of course, who pays the SRA? You do. So unfortunately, it's going to fall onto the profession. But there we go. SRA client money reforms. So basically, these are going on at the moment. There are consultations out there. So you need to get your comments in by the 20th of February. So have a look at those. I'll come back to one of the other things on this in a moment. In fact, here we are. It's urgent consultation. You only have a month to look at this one. This is the government. Some will say money grabbing yet again. Well, this potentially is the case, because what they're now going to do is they're going to set up this ILCA scheme. And in effect, this is so that they can claw back, or they can claw away interest on client accounts. So as you can see there, they are looking to take away 75% of interest from firms, i.e. clients, and 50% on designated deposits. So this is all law firms with interest-bearing client accounts. Now, you might think, well, we can get away with this because we're going to be a TPMA, so we're going out onto these third-party accounts. No, apparently they're being brought into this as well. So whether you outsource it or not, this is all going to impact you. Whether this goes through, I'm not quite sure. There's a lot of resistance to this. Again, it's an article that I've put on LinkedIn recently giving my thoughts, so you might want to have a look at those. I've had a lot of good feedback on that one, but there's a lot of challenge. So, you know, the Law Society is coming out, you know, all guns blazing on this one for obvious reasons. I think the profession really needs to get in there and you know, tell the government what they think of this particular scheme. One of the things that's remaining is that if you get to keep 25% or 50%, depending on which account you're talking about, how much is then reasonable to go back to the client? Now, of course, if 75% been grabbed by the government, then reasonable could be seen as, well, you have to pay them the whole 25%. So that's going to be an interesting one, because, you know, they've already lost whatever the reasonableness, the reasonable sum would have been on 100%. They've now lost 75% of that. And so it's going to cause all sorts of issues. As I say, have a look at the consultation, because there's so many technical issues that could come around this. There are issues around, you know, will you need to have a look at new systems and things like this, because apparently the government's talking about you have to have a compliant system. And well, again, my article on LinkedIn goes into all of this, so you might want to have a look at that. So I'm not going to go into too much detail on that. You can read that either through the consultation or through LinkedIn, but you can certainly see what's coming. As I say, you've only got a month to get onto that one. Government targets professional enablers. Well, it's been continuing to do that. So this is against corrupt lawyers and fraud facilitators, and so they're just basically banging the drum in the new year. I think that's what that one is. So just be prepared for that one. High Court warning. So this is in relation to AI, and we've covered this over a number of months. So basically, you need to be making sure that in any form where you use AI, and we're talking about in this particular case, lawyers who are acting for litigants in person or just assisting litigants in person. Judge in this particular case has warned any lawyer who may have secretly helped litigants in person that they could face contempt proceedings if it turns out that the AI-generated advice they give or guidance or whatever is wrong. So be really, really careful, you know, when you're sort of talking to litigants in person, whether they're family members, friends, whatever it might be. But AI very much up there. Housing disrepair claims. So if you're involved in that, they are, again, proposing reforms around this particular area of claims. And one of the things they're talking about is banning referral fees, which is an interesting take. So have a look at that one. And the reason why I say it's an interesting take is, why isn't it a ban on referral fees in the conveyancing world? Because this particular individual, so this is an estate agent, they've basically disavowed referral fees, saying no kickbacks, no introducer fees, no small print. If we recommend somebody, it's because they are good at their job. And obviously that comes off the back of the BBC Panorama investigation, where obviously there was detriment to clients around this. And of course, there's major focus at the moment on changes in the conveyancing world. And of course, referrals is up there with it. And I keep on adding to the debate as well. And one of the questions I've got is, well, if a ban is good enough for personal injury work, and it's going to be looked at in terms of housing repairs and all that sort of stuff, well, if it's not good enough for those, well, why is it good enough for conveyancing? Are conveyancing clients seen as second-class citizens? What is it that is special about conveyancing that means that referral fees should stay in their current form? I'm made aware by a lot of conveyancers that a lot of unethical conduct that goes on around referral fees, and a lot of them do not take them, or they've moved from firms where they did take them, and all the sort of the shenanigans that were going on around that. So my view is we should be getting rid of them, and people should be able to stand on their own 2 feet, but we'll see what comes of that one. Law Society is announcing research, again going back to what I was talking about in terms of people being prosecuted and then being landed with massive costs, even though they may be found innocent. Well, it's basically driven the Law Society to announce research around establishing a standalone defence union. And it's to support solicitors appearing before the Solicitors' Tribunal. Now, question, when I first sort of saw this, I thought, well, hang on a minute. First question in my mind is, well, why has it taken so long? We've got a law society out there who is supposedly representing its members. It must surely have seen all these issues. Why is it only now asking that question? Do we need to have a defence union? For me, it should have been years ago that this was being looked at. But it may be that because of the escalation in costs, that it's now got to such a bad position. I have been talking to other specialists in the compliance world and regulatory world. They do have concerns that actually it won't work through a defence union. So it will be interesting to see where this one comes. But whether there is a defence union or not, I think you should be looking at a particular insurance, self-insurance, whatever it might be, just in case you get on the wrong end of the SRA. And looking at the cases where they've been found innocent, it could be any of you at any time where the SRA decides, well, we're going to have a go at these people. Now, as I say, one hopes that the case I was talking about earlier on, where the Law Society, you have got to pay all these costs, that may actually stop them. But who knows? We'll have to see on that one. So this is the SRE prosecutions fails. So this is 2 high-profile prosecutions that failed recently. And it basically follows on from what I was just saying. They have got to pay their own costs, because in effect, you've got this precedent where, in effect, the SRA has to be able to carry out its regulatory operations and such like, and shouldn't be hindered by the fact that it will have to pay its own costs. Now, of course, the case I mentioned earlier on, clearly it didn't meet the threshold for that. Whether that changes things going forward, not quite sure. But as I say, clearly in these 2 prosecutions, the individuals or their firms had to actually pay the costs in this. Just to let you know, these were the excuse me, These were slap cases, and so these were the bigger firms who had the money and the wherewithal to basically challenge the SRA. If you're talking about a small sole practitioner, small high street firm, are they going to have the wherewithal to sort of challenge the SRA? Well, clearly, they need to be in a position to be able to challenge the SRA. You've got to hold them to account in terms of what they're doing, but we'll see on that. SRA response to Mazur. So there's still a lot of things going on around Mazur, and rightly so, because it's causing all sorts of problems. So self-reporters, there will be a sympathetic response from the SRA. What is sympathetic as far as the SRA is concerned is anyone's guess. But people will take previous histories of the SRA's approach and make their own sort of conclusions on that one. But in effect, what they're saying is you need to self-report. If you don't self-report, then the likelihood is you're not going to get that sympathetic response, of whatever definition that is. So if you feel that, you have fallen foul of Mazur and things like this, get your self-reports in so the SRA can't then turn around and say, well, you didn't report it. Now, if they are flooded with reports, so be it. They've sort of put us in this position. And what more can they expect if they're going to say to people, well, we'll take firmer action against those who don't report? Fine, report it and let them deal with it. Law Society is to intervene in Mazur, and that doesn't surprise me at all. Court of Appeal case. So the appeal from the Chartered Institute of Legal Executives. So that's going to happen on the 24th of February. So again, this is something that needs to be watched. Hopefully we will get, we will get more clarity around this. So just watch that one. SSB Group regulatory action. So this was just before Christmas, where we actually got a little bit of an insight into what's happening with the SSB solicitors and directors. Well, the non-solicitor directors, as you can see, have been disqualified, and there's 4 solicitor directors under investigation. And the first question, because as many of you know, I do a lot of work around the post office scandal, helping the postmasters and sort of pushing for accountability and things like that, is, well, why aren't they taking the same action against the lawyers involved in the post office scandal? So, we had the court cases going back to 2019-20, and yet there are lawyers still working for the post office who quite clearly have been unethical in what they've done. I say clearly, that is based on the evidence that we've heard through the public inquiry. And I think any reasonable person, having looked at that evidence, would say these people have been completely unethical. Well, if people in the SSB side of things are under investigation, have had their practicing certificates restricted and things like this, well, we've got the biggest miscarriage of justice in English history. And yet none of the solicitors have been subject to restrictive practice. It just doesn't make sense. And I keep on sort of asking the question of the SRA around that. And to date, they just will not answer. All they say is, we've got 20 live investigations going on, and we'll wait for Sir Wynn's report. Well, that seems to be what everybody says. I was watching the select committee hearing yesterday, where the lawyers acting for the postmasters were there. Some of the sub-postmasters were there, but they were in effect questioning Fujitsu, the post office, and government ministers. And it was all about, we're waiting for the public inquiry report. Why? They weren't waiting for full investigations to be completed in either the SSB or Axiom cases. So why do they have to have a difference with the post office? I just don't know. Law Society SGM threshold, not necessarily a compliance one, but I wanted to put this one up here. But basically, the threshold vote was won. There was a turnout. So this was the poll that was sent out to 218,000 solicitor members, and only just over 5,000 responded. So on that basis, 2.4%, it basically you're going to have to be able to have more people backing you if you want to put in an SGM, which has not gone down very well with the conveyancers, who, of course, tried to overrule things in, a few. I'm talking about different years now, but I think it was either last year or the year before. But yeah, there's a lot of unhappiness about this particular vote. SARs. So I never forget to mention firm-wide risk assessments. Here's why you need to update your firm-wide risk assessment, because the SARs annual report has come out. You can have a look at it. Apparently, the legal profession doesn't get a mention in terms of the numbers and things like this, because what the report is so low, it just doesn't fit on the graph. But you've got the numbers here. What I would be doing is just making sure that you put something in your firm-wide risk assessment to say you've read it, you have or haven't identified any changes that need to be made to what you're doing around AML, and hopefully you're then going to be clear of the SRA. But you can see right in the middle there in red, over 1,800 DAMLs were refused. So it is not a foregone conclusion that you're going to get consents or defences, should I say, when you apply for them. The good news down on the right bottom, 2.9 days turnaround. Well, that's what we need, because obviously, when you've got clients sort of trying to push you to get things done, the last thing you need is to be waiting for days and days and days where you can't really talk to anybody about anything. So, that is a little bit of the good news. HMLR avoidable requisition rate. So most firms 20% plus avoidable requisitions. So we need to be looking at upping the game in relation to that. But there are low rates of issues with the largest conveyancers. And the question I would ask, and it's only a rhetorical question, if the data is right, what are the larger firms doing to get it right that the other firms aren't? Is it the use of technology? Is it the fact that perhaps they are using, and this is no disrespect to those who are qualified conveyancers, but are they using people who perhaps aren't as good as others? And what this is in effect saying is we've got a load of potential professional negligence claims building up here because, things are just being rushed through. People are not thinking about it. Who knows? I think it's just one that has to be thrown out there as a possibility. New HMRC requirement. So this is having to submit SDLT returns. You've got to be registered as tax advisors. This is all part of the Finance Bill 2526. It's effective from May 26, and I think, if my memory serves me right, there is a 3-month lead-in period. Let's say lead-in period, sort of probation period. So from May for 3 months on from there. So make sure that you are registered as appropriate. So SDLT returns need tax advisor registration. Chief Ombudsman. So we've got a new Chief Ombudsman coming next month. So you can see who it is, his background and things like this. I'm going to move quickly on because actually, is he going to be in place for very long? I suspect not, if the CLC and the Legal Services Consumer Panel have their way, because in effect, and I agree with them, they are saying there needs to be root and branch reviews, should not rule out total redesign of the scheme, independent review tasked with recommending radical transformation, not incremental change. I definitely agree with all of that. I think the Legal Ombudsman has had its time. We have seen for years and years and years where it has got more money, it hasn't performed, it hasn't met its own internal targets. And I think everybody has just got to a stage now where they've had enough and they've said, well, if you can't do it, let's get somebody else to do it. Let's look at what's going on. So I think there's going to be a lot of change around the Legal Ombudsman this year. So watch out for that one, and we'll see where we go with it. Digital communications. So a lot of firms these days are using different communication systems. So WhatsApp in this particular case. You need to, excuse me, and this is for client matters. So you need to be making sure that if you are using WhatsApp and other systems, secure systems, then you need to be making sure that you can actually support your costs. And so if you are doing things on WhatsApp, as we saw in this particular case, things weren't noted. And so when it came to getting costs, the senior judge turned around and said, no, you know, we need to have evidence to back up the charges that you are putting. So failure to disclose WhatsApp messages meant non-compliance with unless orders to disclose digital files. So do make sure that, you know, it's all well and good adopting new technology, but make sure that, you know, you have the relevant evidence to back up the time that you've spent using it for client purposes. Notable disciplinary cases. So these are the top ones. I'm not going to go through every one of them. The only one that I would sort of question is the one at the top left, fraud facilitation. So this is facilitated 1 fraudulent and 3 potential fraudulent property transactions. And yet all they got was a suspended suspension. A suspended suspension. So they were suspended, but it was then suspended again. Well, I thought fraud was one of these things where actually it was important. It was something that you needed to make sure you got right. But this suggests otherwise. Now, of course, you've got to read into the detail and things like this, but it really just stood out as one that said to me, well, hang on a minute, fraud and a suspended suspension just didn't sort of sit right. But I'll leave that for you to sort of think about. But clearly, the rest, and as I say, I only show 5 or 6 these days rather than the list I used to show. You know, there are still lots of things going on out there. And in fact, excuse me, there's one there that I just want to pick up in terms of the COLP report that I spoke about earlier on. So here we have in the middle, dishonesty. COLP pretended to be working at work while working from home and continued lying about it. So why was that person a COLP? Begs the question, doesn't it? So it's certainly not going to be a COLP anymore because they've been banned. But there you go. It raises all sorts of questions around the COLP regime, doesn't it? So key compliance actions for you. Keep an eye on the new complaints handling rules because they will be coming out. Well, we've got three days until the deadline. So depending on what the LSB says, we'll either get it's not going to happen, or yes, it's all going to happen and we now need to change things. So you'll then need to look at your policies and procedures. If you are subscribing to our policy and procedures library, of course, we will deal with all of that for you and then we'll release it out to you. If you're COLPs, or even if you're not COLPs, can you pass the COLP report stuff back to your COLP, get them to read it? And hopefully it's just a matter of, yep, we're doing all that stuff right, so that's no problem at all. But it may be that there are some lessons to be learnt out of the report. So, you know, they're always good to read. AML Supervision Transfer, just a matter of watching that one and being aware of it. There have been, I was made aware of it on LinkedIn the other day, there has been some scaremongering going on with some businesses who are looking for business from law firms around consultancy and things like this, who are basically saying you need to do this and you need to do this by this particular time. There are no timescales yet. There is a consultation going on. There are no timeframes that we've been given in terms of when all this is going to happen. And the FCA has been very, very clear to say that if you are compliant with the regime as it is today, then you will be compliant going into the FCA if that eventually happens. So if you do start to see marketing materials coming through saying, oh, you've got to do this by such and such a time and this is FCA required, no, it isn't. And I would be grateful, you don't have to mention names or anything else like that, unless you want to. But I'd be grateful if you do get anything like that. Just let me know so I can keep an eye on what's going on in the market and inform others. Number 4, so the client money reform. So lots of things going on there. So particularly in relation to the interest on legal client accounts, so the ILCA regime. Just make sure you get your thoughts in on that particular regime and that particular consultation or any other consultations that are going on at the moment. As I say, they're not giving people a lot of time on these consultations. So, it's in your interest, particularly if you're using client interest to help support the firm, subsidize other areas of work, or, you're offsetting, or however you're using client monies, you need to get your thoughts in there. And the risk assessment update, so update your firm-wide risk assessment where appropriate in relation to what I was talking about earlier on SARs. So hopefully that gives you a good insight into the sorts of actions that you need to be looking at. Now come to questions. So if anybody has any questions, I haven't got any on the system at the moment, but if you do want to put anything on there, then please do. We haven't got as much as we normally have each month, but I'm sure the year will move on and we'll see a lot more stuff. So a bit of a shorter one this month, but if you do have any questions, put them on. If you haven't, thanks very much indeed for attending, and hopefully we'll see you next week or the week after. But definitely, hopefully next month for the update. So yeah, I think on the basis that there aren't any questions coming through, again, you can actually contact me direct if you do have any questions that perhaps you want to ask offline, then please do. But on that basis, thanks very much indeed for attending, and I'll see you again soon. Bye-bye.